Sherrilyn Ifill is former president and director counsel of the NAACP Legal Defense Fund and the founding director of Howard University's new 14th Amendment Center for Law and Democracy. She also informally consulted on the Colorado case to disqualify Donald Trump from the ballot, and she joins me now. I don't want to make too much, Sherrilyn, of one poll that was a snap poll taken just in reaction. But in some ways, I think it's instructive because it's sort of a first thought, best thought kind of thing. Like, it comes down, what do you think? And I'm curious your reaction to that, saying that 54% of voters approve, 33 disapprove of a decision that I think in the mainstream discourse has been far more contentious.
Yeah, thanks, Chris. You know, of course, I'm heartened that a majority of those polled said that they approved of the decision. The folks that you interviewed, that your team interviewed, who said, you know, it won't change my mind, it's just a setup, they're still just charges, and all the things they've said about the other cases involving President Trump, you know, it's very much like what people would say maybe in, you know, the neighborhood next over from me about someone who was arrested and accused of being a drug kingpin. People who've seen that person in the neighborhood, who liked that person who handed out turkeys on Thanksgiving, who was a funny person and engaged with people, would say all of those things. So that doesn't trouble me that there are people who are saying, I'm still with him. I think it's good that a majority of people are hearing this and feeling like there is something there. The good news about Section 3 of the 14th Amendment is that it's easy to read. There's really nothing confusing about the language. That's my first reaction. The second reaction, Chris, is I don't care. We don't put questions of legality or eligibility for the ballot to polls. These are the words of Section 3 of the 14th Amendment of the Constitution. We don't run a poll on whether if Donald Trump said he was 34 years old, or if he didn't continuously live in the United States for 14 years, which is another requirement. We don't put that to a plebiscite. Those are the qualifications for those seeking this office. And the reason it's so important, Section 3, which is, you know, comes to us after the Civil War, is that those framers, Chris, had looked insurrectionists in the eye. They had faced a divided and broken country. They had seen the ultimate in white supremacist ideology. And Section 3 was included precisely because they understood the danger of these two strains in American life to undo the possibility of the new democracy that was being created after the Civil War. And I think for the last 5 years, so many people have been throwing up their hands saying, we've never seen anything like this. What can we do to stop someone like Donald Trump? Yes, it's true. We haven't had to deal with this since the Civil War. Thank goodness, because most of our presidents, all of our presidents, save one, have not tried to overthrow the legitimate election of their successor. But the framers of the 14th Amendment created tools for us to be able to deal with the possibility that there would be those who would be in this position. And the simple phrase tells us that what they're saying is that if you are disloyal to the Constitution of the United States, having once taken office and taken an oath of office in the past, and then engaged in insurrection or rebellion, or having provided aid and comfort to those who did engage in insurrection or rebellion against the Constitution, you are ineligible for public office at either the state or the federal level. It's perfectly logical. It's there. It was created by these framers. And I think it's very easy for people to understand.
You know, one of the things that has been a recurring theme of this era, right, is that Trump pushes against every boundary around him and sees how far he can go, right? And one of the things I've thought about actually in the wake of this, and this has been occasioned by a few people making this point, it is interesting, right? We talk about the 34-year-old or someone who is, you know, not a U.S. citizen or not a natural-born citizen, right? Like, clearly, like, you couldn't put a 20-year-old on the ballot for president, right? We all understand that. And the thought I had was, as you watch this sort of interesting granular question of like, oh, well, how does this actually work, right? State by state. And in Maine, the Secretary of State's going to decide. And in Colorado, the voters can sue. And I had the thought of, well, what if someone, Donald Trump, for instance, wanted to seek a third term? Clearly, the Constitution says he can't. And clearly, you could say, well, it would be anti-democratic to not have them on the ballot. I mean, the people should decide. But no, actually, in the Constitution, you're right. In the Constitution, we're just sorry. We're just clear about that. But then the question becomes like, right, when the rubber hits the road, if a certain person says, I'm running for a third term, it turns out it's just going to be a test of the same sets of institutions and laws, right? That whether they can say, no, you can't.
Exactly. And this decision by the Colorado Supreme Court is incredibly thorough, goes through all the evidence. This is a court that understands what the stakes are. It will head to the Supreme Court. And as I've said in the past, this is really going to be a test for the Supreme Court because the plain text of Section 3 of the 14th Amendment is very clear. The findings of the trial court and the affirmation by the Colorado Supreme Court are very clear and well-founded. The dissenters in the Colorado Supreme Court case dissent on grounds that have to do with Colorado state law. And for your viewers who don't know, a state's highest court is the last word on the interpretation of that state's local laws, that state's laws. So the Supreme Court's not really in a position to overturn on the grounds that the dissenters in the case dissented. So this is going to be a real test for them. There are people who've suggested that we're naive to think that they will do the right thing and uphold this. That's not really why we file cases. I'm a civil rights lawyer. I don't file a case thinking the Supreme Court's definitely going to rule my way. You file a case because you have a legal claim that must be vindicated. And this is critically important. We so often ignore the 14th Amendment when it is central to our ability to create a healthy democracy. And at our peril, we have ignored sections of it. We have distorted it. We have upended it. We have used it for ends that it was not meant for. But this section of the 14th Amendment was meant precisely for the occasion in which we would find ourselves now. And by the way, it doesn't just apply to Donald Trump. So I hope that all those other insurrectionists who are holding office or planning to run for re-election, I hope they're sleeping a little more fitfully after this Colorado Supreme Court ruling, because it's not over.
Yeah, and I should note here, Judge Michael Luttig, who has become a very vocal Trump critic and was a sort of legendary conservative, I mean, real conservative jurist. He was set on the Federal Appeals Court before he left. He was in the short list to be a Supreme Court justice. He says that he said it's the opposite of politics, this ruling, that the Constitution itself tells us that disqualification of the former president is not anti-democratic. Rather, it tells us it's the conduct that gave rise to disqualification under the 14th that is anti-democratic. Final question for you is on the second point here about the sort of necessity of there's the 14th Amendment, Section 3, and then there's also, will the legal system be allowed to run its course and have a full trial before a jury with full constitutional rights and due process of this man in time so that people can judge, who they are voting for?
Yeah. So I want to separate this out because there are so many cases. You're right. There is the criminal case. We have Jack Smith's case. We also have, the LDF KKK Act case that got a huge boost today with the finding of phone calls with Trump and Wayne County canvassers in 2020. And so we've got a lot of different things going on that need to move through the system. But, this is still a test for the Supreme Court because they're going to have to make a decision about the very question that you're asking me. They have to ask themselves. In a democratic system, don't the voters have the right to know whether this person is in fact guilty of the crimes of which he's accused or not before they vote in that election? Now, the Supreme Court can engage in sleight of hand. I mean, I could imagine them trying to resuscitate that Purcell doctrine that says we don't change things about an election too close to an election. I mean, it would be outrageous to take a shadow docket decision and use it in this way, but I would not put it past them. They may say on the Section 3 case that there needs to be enabling legislation by Congress to remove someone from the ballot. I mean, there are a million ways I think they will try to avoid this because, Chris, there is no way, looking at the text, at the history, at the intention of the provision, at the trial court record, at the decision of the Colorado Supreme Court, that just on the legality, not on the politics, just on the legality, you could strike down that decision. So that's the Colorado Supreme Court decision. The other cases are those criminal cases that need to move. Jack Smith is trying to move directly to the Supreme Court. I can't think of a rational or even legal reason why they would not accept that expeditious hearing and turn it back to the Court of Appeals. And so I think the Supreme Court is in a tough spot. Of course, they're the 800-pound gorilla. They get to do whatever they want. But every time they depart from what is plainly the correct legal course by the rules that they have created and upheld, every time they depart from that, they further undercut their legitimacy, and they lay the groundwork for the changes that will happen to the structure of the Supreme Court in the coming years. I'm sure those changes will happen, but they will happen more readily and with more public support the more the court is perceived as departing from its own standards and from standards of legitimacy.
Sherrilyn Ifill, always a great pleasure to have you. Thank you very much.
Thank you, Chris.